Seth, I know that the Supreme Court needs to set politics aside, but I do want to ask you how politics possibly might have played a role in all of this, as well as the reactions that we are reading in the dissents. We're going to step away for a 2-minute break. We're going to continue our conversation after that. Welcome back to Live Now from Fox, and you are taking a live look at the Supreme Court after the Supreme Court has sent former President Trump's immunity case back to the lower court. We're going to continue our conversation with Seth Berenzweig, who is an attorney, really has been breaking all of this down before the ruling came down, during all of that, and now we're talking about this. And Seth, it's so interesting because even though this really should not be about former President Trump, a lot of people making it the focus of all of this. Truly, as we are reading this, even though he is named, they're really talking about presidential powers themselves. But I'm curious, this is a presidential election year, a historic one at that. We have a current president who is campaigning against a former president who really was the center of this case right here. So do politics factor in at all? Does it matter whose name is attached to this? Because we are talking about presidential immunity. So I'm sure there is concern when you talk about future presidents, regardless of what party they're affiliated with, how this might impact them.
Well, I think we'd all like to rely on the presumption of everyone's greater angels and to want to presume that the justices are coming at this like Lady Justice with a blinder on and just trying to do justice without any aspect of politics. But unfortunately, the world of reality doesn't allow us to do that because we know, particularly in light of some of the things that have happened within the last couple of years, that politics has become a part of the conversation. Now, maybe it's more fair to say that it's a part of the debate because I'm not certainly going to take a side on that at the moment. But when you have Justice Alito flying flags upside down and you have Justice Thomas's wife texting Mark Meadows from outside the Capitol as people are bursting in, it's just impossible to divorce yourself from the realities of the historic moment and gravity of the situation. So when you look at that, unfortunately, that becomes a part of the filter through which we view this part of American history. And then I go from that into digging more into the dissenting opinion, where I think that they're really taking that question that you've raised on steroids. And they're just basically saying, look, what's going on here? This is what Justice Sotomayor is saying. No matter how you look at it, the majority's official acts of immunity is, quote, utterly indefensible. She also says in her dissenting opinion at page 10, in sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers until now. Settled understandings of the Constitution are now of little use for the majority of this case, so it ignores them. That is saying a point that goes back to Jack Smith's argument in the opening hearing that says there's no constitutional basis of authority that supports the expansive view of executive immunity that's being endorsed by the president. So I think the long and short of it is that is something that blends into the filter of the history of this court and is part of the historic moment that you and I are looking at now. It kind of reminds me of a saying by the owner of the Washington Post that says newspapers are the first draft of history. Right now, you and I, in a way, are reading the last draft of this chapter of history because the Supreme Court has planted a flag that is now going to govern not only this moment of historic American significance, but also how this is going to affect the next few months, how this is going to affect the American election, and how this is going to affect the office of the presidency. So I know that we've gone into a lot of details, but really just kind of taking this on a 30,000-foot flyby, it's just such a momentous moment, and that's why there's just such heated controversy and argument amongst the justices here in Washington.
And we truly are living this historic moment. And it's not just this moment. We have seen time and time again history being made when it comes to criminal cases, when it comes to the cases brought before the Supreme Court, when it comes to the presidential election itself, really from a historical perspective. And I know you're taking this from a legal perspective, but this is a momentous occasion that we are all living in.
Oh, it's just such an unbelievable moment, regardless of how you view the merits or the lack of merits of the allegations. Let's just choose the one case that's the most relevant to the moment, Judge Chutkan's case on alleged election subversion here in Washington, D.C. Regardless of the viability or the lack of weight, this is a moment that weighs very heavily in the balance of American history. And the fact that now the Supreme Court gets to come in and lay down this controversial standard, it really just creates such a richness of context for what's going to be happening next. And one of the ironies of this decision is that although it does a lot, it also leaves a lot up in the air. I think that you'll be hearing some criticism this weekend about how this is kind of reinventing the wheel that might not have been absolutely necessary. Yes, there are a lot of things in this that are a really big deal, but in a way, a lot of this is also just going back, and it foots back to the standard of whether something is or is not an official act. Now, of course, they weigh in on that in a way that I would argue favors President Trump in a pretty tangible way, but we are left with a middle ground. Maybe that's a good concluding point to say that maybe the Chief Justice of the United States found a way to split the baby in a way that provides an appearance of objectivity for the court to provide a middle ground that encircles the presidency in some kind of absolute immunity while not giving up the farm. And if that's one way to look at it, that might be, one could argue, within the spirit of American compromise and democracy. Don't ask Justice Sotomayor. She agrees with me on that. But now we've learned a lot more now than we did an hour ago.
And one last question for you. You went to law school, you studied landmark cases and how it has changed the course of history through the legal channels. When this is put into those textbooks, when this is taught in the classrooms, when this is used as an example for law students down the road, what do you think that general view will be when this is being discussed?
Well, I think that this will probably be presented as the modern version of Marbury versus Madison. In Marbury versus Madison, the Supreme Court demonstrated a flexing of its muscles to demonstrate for all time judiciary power and independence. This is going to be providing added muscle to the zone of unbridled discretion that the President of the United States has in his or her performance of that job and communications that the executive has. It's going to be controversial, but it's going to be a landmark decision. It's going to be taught in constitutional law. It's going to be taught really for many, many years to come, because this is something that's going to have a lot of weight. And unquestionably, we're living through a moment of history here. The Supreme Court has spoken, and now all eyes go to Judge Chutkan here in Washington.
Seth, before we let you go, any final thoughts as we continue to follow this breaking news? It is fresh. Again, the ruling, as you mentioned, is very dense, and we have it in front of us right now. But anything really that you would want to leave our viewers here with, whether it be perspective, whether it will be taking a look at how this might play out down the line? It's been a fascinating discussion with you. As you mentioned, we are living history right now.
Yeah. What I would encourage people to do is to look at this moment in history and at this decision through a lens of respect. What I mean by that is the country is so polarized right now. The country is so divided, and even in the 6-3 decision, the 6 and the 3 are really bickering with each other. But I think that what the Chief Justice has done, and I could argue in an elegant way, is he has done some baby splitting, albeit controversially, to find a way to land in some kind of a middle ground where the president is in some manner protected, in some manner not necessarily protected, and allows the trial in theory to move forward. So I would encourage people to try to come together in the middle and apply a presumption of good faith and to come together and really support the Supreme Court. It's a moment as Americans where we need to support the Supreme Court, we need to support the Constitution, and we need to let the judiciary do its job. And that means that we have to apply the same thing to Judge Chutkan in determining what she does and just letting justice run its course.
Let justice run its course. Seth, it's been such a pleasure to chat with you over really the past hour and a half as we were awaiting this historic ruling during all of this. And now after, as analysis does continue, we appreciate you taking the time to join us and join our viewers here on Live Now from Fox for truly some raw and unedited, unfiltered analysis. We appreciate it.